Kia ora, everybody. Welcome to the year 2022. I hope you had a great new year, and I'm sure it's going to be very prosperous for most, if not all of you, given that you are going to be gaining residence, hopefully sometime this year, under the 2021 residence visa. My name is Tuariki Delamere, and I am the former Minister of Immigration, but from a long, long time ago. Today, I'm the Principal Consultant for TDA Immigration, and I've decided to make a couple of videos. First is this one, which is about the actual policy, the immigration instructions, based on what we now know over the last 5.5 weeks since the applications were open for phase 1 applicants. My second video will be following through an actual application for one of my clients. I thought that might be helpful for you. Now, I hope you enjoyed the introduction. That's Led Zeppelin opening up with the Immigrant Song. So I think it's quite appropriate for this video, and also appropriate for me because it's from the 1970s and I'm in my 70s now. So anyway, let's get started on the discussion. So the first instruction is 6.5.1. Most of you know all about that. The opening and closing dates for phase 1 applicants was the 1st of December 2021. We got over the hiccups of the first couple of days where Immigration New Zealand were totally unprepared for the thousands that applied starting at 6 a.m. on the 1st of December. But anyway, we've got through that. Those of you who are phase 2, you are able to start applying on the 1st of March in 2022. So what's that, about 10 weeks or so from now? And importantly, you must apply phase 1, phase 2, no later than 31 July 2022. If you apply 1 minute after midnight on the 1st of August, that's when you're lodged. Tough, you're out of luck, you've ruined your chance. And I'm sure most of you, well, I'm sure all of you will get it in. Phase 1 and phase 2 applicants. You qualify if on the 29th of September 2021, for phase 1, you had made an application for residence under the skilled migrant category or a residence from work category, or you had a skilled migrant application or skilled migrant expression of interest. Let me start all over again. Shit. Okay, well, let's get started. Discussion on the 2021 resident visa requirements. This is Tuariki Talks. Section 6.5.1 of the immigration instruction sets out the opening and closing dates. 1st of December, phase 1 was eligible. 1st of March 2022, phase 2 are eligible to apply. And you must, everyone must put the application in no later than midnight, 31 July 2022. 1 minute later, at 1 minute past midnight on the 1st of August, tough, you're too late. So don't forget. Now, phase 1 applicants were those who on the 29th September 2021, you'd already made an application for residence and accepted as an application under skilled migrant category or the residence from work category, or you had an expression of interest which included a dependent child aged 17 years or older, okay? If you have an expression of interest and you have children, but none of them were age 17 on 29 September 21, you can't apply. And don't try and be clever and apply. You'll see later in a minute. If your child turned 17 on the 30th of September, you have to wait till March 2022. And if you apply before that, you just cut your own throat and your application will be declined and rejected. Now, phase 2 applicants, that's everyone else. 1st of March is when you can apply, okay? And the reason I mentioned about your children for expression of interest, look at D there. Applications made by a phase 2 applicant before 1 March 2022 must be declined. So, and here's the danger. You put in an application and your child turns 17 on the 30th of September 2021 or after, thinking maybe you can jump the queue, your danger is that may not be declined until 1 August or later. And if that happens, you're stuffed. You're not going to get a residence visa. So don't be tempted by trying to jump the queue, okay? Now, evidence, you're going to have to provide evidence. Now, everyone must provide evidence that you meet health and character requirements. If you are a skilled migrant category applicant that's already been, or resident from work, and your application has received a case officer allocated to a case officer, you've already put all your documents in. As long as your health and character is acceptable, you'll be fine. You won't be, immigration will not come back at you on that. But everyone else, you're going to have to put in the evidence, okay? So when you do your application, put in your health and character evidence if you have it, unless you've already got existing ones that have been there in the last 3 years. Okay, and you must meet the requirements for 2021 residence visa as set out in section 610. We'll get to that coming up. And an application must be and will be declined if an officer is not satisfied that you provided sufficient evidence. So my warning to you here right now, don't rely on a case officer coming back to you and asking you for that evidence, okay? They may come back. We don't know. They just may turn around and decline you. So be very careful and make sure you put the evidence. You can't put in too much evidence, okay? So if in doubt, put it in, health, character, whatever it is. The requirements, okay? You must meet the health and character, obviously. And again, those of you who are tempted to try and jump the queue, look at S610-2. The principal applicant did not make an application in phase 1 when they are a phase 2 applicant, okay? So you jump the queue, they realize it and decline it. One of the interpretations of 2 is that you're not allowed to put an application after that, okay? So if you're in doubt as whether you are phase 1, and they're pretty clear, but if you're in doubt, my suggestion is wait until the 1st of March. Don't take the risk of coming to grief under point 2 here. Now your fees, immigration will sort that out later. If you've already put in fees, expression of interest, your applications for skilled migrant, they'll sort it out. Everyone else, you'll have to pay the appropriate fee. Now, having been here in New Zealand on 29th, that's one criteria you must meet. The other one is you must meet one of the requirements for settled, skilled, or scarce, unless you're a critical purpose visa holder. And you meet the requirements for dependent children, if that is actually appropriate. So here's a list of the eligible visas. The great majority of you, this is the one you're looking at, you're not looking at critical purpose visa being held. You must have held one of these visas, okay, on the 29th of September, or you were granted a work visa under section 61 afterwards, or even at that time, but prior to that, you must have had one of these visas within the previous 6 months. If you're in doubt and not sure, feel free to send me an email and we can discuss it. So you must have held an eligible visa and or you've made an application or request for reconsideration of an eligible visa that was subsequently granted after the 29th September. And I said, you must have been in New Zealand on that date, 29th September. Now, those of you who may have been in Australia on that date, and you left New Zealand between 6 April 21 and 23 July, you are probably eligible for it. If you're not sure, send me an email and we can try and help you sort it out. And if you held a critical purpose visa on or after 29 September, you may also be eligible. And again, I won't get into great detail. It can be a bit complicated. So again, send me an email if you're not sure. And people granted a critical purpose visa, like I said, if you've been 6 months or longer for the visa issues, you should qualify for this. But again, send me an email if you're not sure. Most critical purpose visas, they got a listing of what qualifies. One of the things that doesn't qualify is if your visa was for deep water, deep sea fishing crew, agriculture and horticulture, mobile plant operators, shearers, and recognized seasonal employers, you don't qualify. Okay, we'll just skip through the critical purpose. Right, requirement to be settled, skilled, or scarce. This is what the great majority of you will be applying under. Probably the most of you will be settled. So you must meet one of those three. Now, settled, if you first arrived in New Zealand before or on 29 September 2018, and it doesn't matter if that was you paid a holiday visit 15 years ago, you came in for a couple of days and left, you meet that standard, okay? But you must have been in New Zealand sometime on or before 29 September. And from 29 September, that's 2018, and from that date through to the 29 September 2021, you must have been in New Zealand for at least 821 days. Now, Immigration New Zealand will make that determination. You don't have to provide any evidence. They know if you were here. Don't apply for it if you don't meet it, okay? Go back to where I said before. Be careful. Now, most of you who have existing applications, I imagine 99% of you will meet settled criteria, but immigration will determine if you do. But again, check your dates. It's 821 days. It's not 820. So if you've got 820, I've actually been contacted by someone who's 820, that person be trying to make an argument why they should be allowed. You won't be allowed, okay? So don't bother trying. And there are people who've arrived after 29 September 2018 for the first time and been in New Zealand for 900 days or more. You don't qualify either for this particular category. Now, skilled criteria, that's the one, did you earn $27 or more per hour on 29 September 2021, okay? If you did, then you meet the skilled criteria. Now, that employment must be full-time. That's at least 30 hours a week on average over an agreed pay period. The employment must be genuine, and it must be for a position that is paid by salary or wages. And if you're a contracted person for services, you may also qualify. You have to have a consistent history of contract work and a current contract for services. So you can't just all of a sudden dream up and write up a contract of service for the starting the 27th of September or whenever, and expecting Immigration New Zealand to accept that. They won't. You must have a current contract, of course, but you must have a history of that. And the only way to prove that is through the tax department. And we'll cover that in a minute when we get to 6:15:20, how your remuneration is calculated. Okay, if your pay rate has fluctuated because of COVID, immigration can and will take that into account. If you're not sure, send me an email and see if we can work through it. Now, the evidence you need for skilled criteria, as I mentioned earlier, you must provide with your application the evidence that you qualify. So you must send it in. If you don't send it in, you run the risk of being declined. You run the risk of Immigration New Zealand not coming back to you with a PPI, point of prejudicial information. You're required to submit it on application. So put it in. Now, evidence for skilled criteria, you got to prove that you earn $27 an hour. Putting in an employment agreement by itself, dated 27 September, saying you've got $27 an hour, that is not proof. Anyone can write up an employment agreement and date it before the fact. What you have to show is your full bank statements that shows you've received your net pay equivalent to being paid $27 an hour, and or your summary of income details from Inland Revenue and or your pay slips. I do not believe pay slips by themselves will be satisfactory because, again, anyone can print up a pay slip. That's not proof in my mind anyway. Now, perhaps you'll be lucky and your case officer will let it slide. I don't believe they will, because the only true proof is seeing in your bank statements. The pay slips will show what your net pay is. The bank statements will show that you received your net pay, and the income tax reports for you yourself will show that your PAYE was also paid and also indicate what your gross was, okay? My advice is you should show that information for at least the whole of September and October, as a minimum. Now, and the officer, they may come back and ask you to provide further evidence. They're entitled to do that if they've got justified reason for doing so. Now, the next category is the scarce criteria, okay? Huge list of qualifying occupations. And you must prove that you were working in those occupations, or one of them that's qualified, okay? There's a list of them. If you're not sure, by all means, send me an email and we'll see what we can do. But again, with everything else, full-time, genuine, and paid by salary or wages. You don't have to earn $27 an hour if you're in this category. You must be paid at least the minimum wage, though. Similarly with contract work, you'll need to be paid at least the minimum wage and a history. If your occupation requires provisional or full registration, you must have that. If you don't have it, you're not going anywhere. You won't be approved. Now, quite a few of you who are working, a lot of people working as personal carers, retirement homes, places like that, or even in hospitals. If you are working in there, you must have one of those occupations, be working one of those occupations, okay? You can't be working as a corporate function, human resource, office administration, property maintenance. You can't be the cleaner. You must be one of the eligible scarce criteria occupation, okay? Again, if you're not sure, send me an email. And again, if your work hours were disrupted because of COVID, you may still qualify. You need to explain and provide evidence of why you were not working at a particular time. And obviously, in some occupations at level 4, you weren't allowed to go in, so you couldn't work during that time. And Immigration New Zealand will take that into account. You won't be penalised. Evidence, again, as I said at the beginning, you can't provide not enough evidence. For scarce criteria, first up is your employment agreement, well, your job description, and any other evidence that you can think that supports the occupation you're claiming to have worked in, okay? And this is, you need to be very careful on this because this is actually very important. Whereas, for claiming the skilled $27 an hour, the employment agreement job description doesn't really mean diddly anything. In this case, the scarce criteria does. But immigration will also check your previous work history and compare job descriptions from then to what the one you're claiming now. So if you've changed your job description since getting your essential skills work visa, immigration can let that go, but they're going to investigate and see if what you're claiming is reasonable. And not, fraudulent, not providing false information. And like I said, if you haven't been previously assessed on that, they're going to check you, okay? So at the minimum, you'll need your employment agreement with a job description and or a letter from the employer stating your occupation, what you do, and the hours you're working, okay? And the officer can ask for any other further information if they are not satisfied with what you provide them. But again, like I said before, don't wait and hope that they will ask. If you've got evidence, put it together, send it in. Don't take the risk of being declined. Your employment must be genuine and you must meet the appropriate pay rate that you've been contracted to. And immigration will check in that to make sure that you've complied or your employers complied with the principles of the Wages Protection Act. At all stages, your remuneration will be calculated back on your payment per hour. It must be $27 an hour. So if you've got a salary, they will divide it by 52, then divided by the hours that were worked each week. And it must come to at least 27. If it doesn't, you don't meet skilled criteria. And they'll also do that for scarce criteria to make sure that you're paid at least the minimum wage. Okay, we'll just flick on through this. Now, remuneration includes obviously your pay, your gross cash pay, if you like. But for those of you who are receiving accommodation and meals, and this often happens, people who are working out on the farms, you're allowed to claim a certain amount for accommodation. And this is actually one where you have some flexibility, okay? And I guess with the high rental rates in Auckland, if you're in a remote farm, it gives you a bit more scope to perhaps claim at the higher rates for accommodation if you need to meet that $27 an hour. But you can't claim things like, taller uniform allowance and bonuses, which are dependent on performance, okay? So those of you who are getting bonuses, commissions, you can't count that. You can only count income, remuneration that is guaranteed no matter how you perform, okay? So commission and bonuses are out. And the meaning is accommodation. If you want to know what the definition is, go to section CE1 of the Income Tax Act. I wouldn't bother if I was you, it's really boring. Overnight hours. This impacts on you who worked in aged, residential care or disability care. If you are required to stay overnight and you're allowed to sleep, you don't have to be paid at your normal rate, but you must be paid at or above the minimum wage. And when you are actually working, like if you get up during the night and do something for an hour, then for that hour, you must be paid your normal rate, okay? So when you do this, be very careful because, always err on the side of caution. Look at it from the factor that you think the immigration officer is going to do their damnedest to decline your application. So you need to cover all that. So don't be lazy, get the evidence in there. Okay, well, look, I hope that's helpful. There are us, TD Immigration. We're at 441 Queen Street. There's our phone number. There's our website. There's my email. If you got any queries, by all means, drop me a line. Okay, everybody. So that's the first video. Those of you who want to see how an actual application form comes out and is done, tune in to my second video. So take care.